Okay, good morning, good afternoon, and good evening. Ladies and gentlemen, my name is Quentin Vale. I'm a Senior Director here at Meritas. Very warm welcome to you all for this special online session on the US sanctions that have been imposed on Russia following their invasion of Ukraine. I'd just like to take a moment, and I know there are some people attending and others within the Meritas network whose countries are directly being impacted by the ongoing crisis, both on an economic, social, and indeed a humanitarian level. And they will have friends, families, and contacts in Ukraine. And so our thoughts and best wishes very much go out to them. Before I introduce you to our speakers for today, just a few housekeeping notes. Please note that this session is being recorded and will be made available to Meritas members after this session. Can we ask you to please stay on mute during the presentation, as that really helps with the audio. Naturally, when we get to the question and answer session, please then come off mute so that we can hear you. Please also feel free to use the chat feature at the bottoms of your screens, both to make comments about what is being spoken about and to raise questions, and we will take those questions after the presentation. So I'd like to now introduce you to our speakers, Brian Walsh, Megan van der Schaaf, and Michael Cooper-Smith from Barnes Richardson. Barnes Richardson is a US member firm based in Chicago and is a specialist in global trade law. They've been actively involved in advising their clients on the wide range of sanctions that are being imposed on Russia. I'd like to take this opportunity very much indeed to thank Brian and his team for today's presentation, especially given the very short notice that we provided. I think I spoke to Brian this time last week, and to turn this around in such a short time, especially given how busy they have been, is massively appreciated by Meritas, and I know by member firms around the network. So, without further ado, I'd like to hand over to Brian to introduce himself and to his team, the firm, and then to launch the presentation. Brian.
Thank you, Quentin. Yes, as mentioned, my name is Brian Walsh. I'm a partner in the Chicago office of Barnes, Richardson & Colburn, a firm that has concentrated in the areas of U.S. customs and international trade law since 1919, with offices in New York and Washington, D.C. as well. And speaking with me today will be Megan van der Schaaf, Senior Associate in the firm, and Michael Cooper-Smith, associate in the firm, both in the Chicago office, who have been, frankly, up to their ears in this topic for the last week. And I can say that as a regulatory attorney, what we've seen over the course of the last week is truly unprecedented in terms of speed, scope, and scale in the issuance of sanctions and changes to the export control regime with regard to Russia, Belarus, and the newly independent territories, newly declared so-called independent territories. Saw one report this morning, someone who tallied it up said that there have been over 1,200 pages of regulations issued over the course of the last week. So this is all very new and is very much in flux. As we were putting together the slides for today's presentation, during the course of doing that, additional regulations were being issued. So this is something that people need to stay on top of in current time when advising clients. And we're seeing regulations that are issued that are effective immediately upon release, prior even to publication in the Federal Register. So it's constantly changing. One of the things just to remark upon initially with regard to these regulations in particular the export control regulations that are administered by the Department of Commerce, the Bureau of Industry and Security. These are different than some of the export control and sanctions regimes that we've seen in countries, applied to countries such as Cuba or North Korea, where there's basically an across-the-board prohibition for dealing with those countries or exporting those countries. This regime, as far as exports, is more selective, which people may be a little bit surprised about. So there still will be currently, as of this moment, trade of substantial items with Russia allowed, but it also places an onus on exporters to make sure they're doing it right, because there's been also at the same time a substantial number of things that have been placed as prohibited or requiring a license. So Michael, can you put the slide up? So what we're going to cover today is first the background and what we call the list-based controls. And this background is going to be necessary because, as you'll see, the controls are somewhat selective, and you need some understanding of the actual background to understand what's taking place. Then we'll talk about changes specifically in the new regulations and steps for compliance, which we're going to highlight throughout. Then the Treasury Department sanctions, which are separate from the export control changes that have been made under the Commerce Department. And we'll talk briefly about penalties, enforcement, and licensing. Okay, advance. The first thing that we need to identify is under these regulations, and we're talking about the Export Administration Regulations administered by the Bureau of Industry and Security of the Department of Commerce. These regulations apply to all items in the U.S., in foreign trade zones, or in transit, all U.S. items wherever located. And this is where we need to focus, becomes a little bit important. U.S. origin parts, components, materials, and other commodities incorporated abroad into foreign-made products, U.S. origin software, U.S. origin technology commingled with foreign technology exceeding de minimis levels. So these regulations apply also to U.S. origin parts used in the manufacture of product in third countries. So for instance, U.S. subsidiaries abroad or foreign corporations producing merchandise using parts and components abroad. Next slide. Or foreign-made direct products of U.S. origin technology or software. Okay, so something that's used or something that's manufactured on the basis of U.S. origin technology. As well, certain commodities produced by any plant or major component of a plant located outside of the United States that is a direct product of U.S. origin or U.S. origin technology or software. So it's a huge, huge scope, a very broad scope that is interpreted to be applicable under these regulations. All items specified on the Commerce Control List, and that's part of the regulations, part of the Export Administration Regulations that we'll talk about in a moment in more detail, and certain items not specified on the CCL, also known as EAR 99. And I suspect that some of you may have heard of EAR 99 as well. Okay, next slide. So the Commerce Control List is basically, it's a list of anything that can be exported from the United States. Is either subject to a specific ECCN number, Export Commodity Control Number, or falls under the basket category of EAR 99. And this division between ECCN covered articles, merchandise or technology versus EAR 99 products is also known, particularly in Europe, as the distinction between dual use items and non-dual use items. And this distinction between products that are specifically covered by ECCN or are under the basket category of EAR 99 is particularly important given the current state of the regulations with regard to Russia. Now, typically, what the export licensing exercise would be to identify the specific ECCN that a product or a technology is covered by under the CCL, and then refer to a country chart which lists all the countries that may be subject to export. And if there's a box under that level of control in that country, then there's a license requirement. And there are certain license exceptions as well that can be applied. Okay, next slide. So the ECCN classifications and what's governed by those classifications cover not only the particular article, but they can include, or they do include, technology, software, technical data, and so forth that are related to that particular controlled item. So when we talk about export control and licensing requirements, we're not only talking about the particular item itself, but we may be talking about information, plans, specifications, and so forth that deal with that particular item. In addition to export of those particular articles or the particular information physically from the United States, there also can be exports of technology or information under what's known as the deemed export rule. And this would be the disclosure of technology or information that is controlled under a specific ECCN to a non-US foreign national. Okay, so think about, for instance, sharing plans or technology for a controlled item, or access to a database, a corporate database that has such information. That is a deemed export. In most cases, that's not an issue, but if it's licensable, if that information is subject to license, then it does become a problem if a license is in place. And under the current regime that we're going to be talking about, that technology that is non-EAR 99, if accessed by a foreign national, would be a licensable event. That would be a deemed export, whether it took place remotely, whether actual physical paper documents were shared. That's something to be alert to and concerned about. Okay, next slide. Now, EAR 99, this is the basket category that we talked about. And these are items not designated under the control of another federal agency or listed on the CCL as a particular ECCN. So they fall in this basket category of EAR 99. So think low technology, consumer goods, brooms, rugs, furniture, non-high technology or even perhaps medium technology articles fall into this category. And clients up till now should have been very, very careful in making export commodity control number determinations and classifying their goods to be exported, whether they're EAR 99 or under another ECCN. But this determination has become very, very vital in terms of these regulations, because the EAR 99 products, as will be explained in a few minutes, are under much less control than those dual use or ECCN controlled articles. And I can guarantee you, we've seen over the years many companies that have not paid sufficient attention to classification and have defaulted or assumed that those articles are EAR 99 and subject to a low level of control. This is going to lead to problems under these new regulations, to the extent that that determination that an article is subject to EAR 99 when it is not. Okay, next slide. Now, when an article actually is subject to licensing requirements, there's a process where the exporter can apply for an application through the SNAP-R system of the Bureau of Industry and Security. And licenses are generally issued for a period of 24 months in a specific quantity. We're told that these license applications currently are running under a month in turnaround time. Okay, so if your clients have an article that needs to be licensed, obviously this is submission through SNAP-R is something that needs to be done. Now, the decisions that can come down from such a license application, there can be denied, there can be approved, and there can be an NLR determination, no license required. And in this context, those sort of determinations are going to be important, because that's basically the agency saying that no license is required for this shipment. It can proceed. And I can tell you that on Tuesday we had basically a private briefing by an agent of the Bureau of Industry and Security, enforcement agent, whose recommendation was that for any shipment to Russia that involved products subject to an ECCN or to a Russian state or state-owned enterprise or government agency, that a license application be submitted. Okay, and with that, I'll pass the baton to Megan.
All right, so as Brian just talked about, there are license requirements, and there are new license requirements as a result of the Russian invasion of Ukraine. So these license requirements became effective February 24th, but they were only published in the Federal Register officially today. So there are 3 distinct types of licensing requirements. I'm going to talk about the first one, and then Michael's going to talk about the ones that apply to foreign produced direct products. But the one I'm going to talk about is the license requirement that requires a license to export, re-export, or transfer in country any items in categories 3, 4, 5, 6, 7, 8, or 9 of the CCL. So these items were generally controlled at a lower level under the EAR, but because they are necessary for things like aircraft, vessels, and electronic items, they're now subject to controls. So these categories, there's a list there of some of the items, but the categories are for electronic design, development, and production, computers, telecommunications, information security, sensors, lasers, navigation, avionics, marine, aerospace, propulsion. So the intention with this restriction is that now Russia will not have access to easy access to these products that they're not able to produce domestically. And then where this is even expanded is that Brian talked a little bit about the de minimis rule. So I'm going to talk about that a little bit more, and how this new licensing restriction applies even to products that are not produced in the US. So the The way the de minimis rule works here is that in certain circumstances, foreign-made products that are produced with US components are subject to the EAR if the value of the incorporated US origin controlled content exceeds a certain percentage. And that percentage ranges from 0 to 25%, depending on the level of control and the destination. So this applies when you have a US commodity that incorporates US origin controlled commodities, is bundled with US origin controlled software. If the non-US made software incorporates controlled US software, or you have non-US made technology that's commingled with controlled US technology. If you have any of those situations, the non-US made item becomes subject to the EAR if the value of the incorporated US controlled content exceeds, there's 3 levels. So in the most stringent level, the 0%, those are specific kind of products like certain semiconductors, high-speed interconnect devices that are used in high-performance computers, and certain encryption items. The next level up is 10% US content, and that is going to apply to items that are going to go to places like Cuba, Iran, North Korea, or Syria. And then most other items on the CCL will fall under the 25% requirement. So that's for those most items on the CCL and EAR 99 items that are going to Crimea and Ukraine. So the new licensing restriction will apply to Russian exports, and they will be used to make this de minimis calculation. You can get an exception if the CCL, if the ECCN item is only controlled for AT or anti-terrorism, and the item is made in, will be re-exported or exported from the partner countries that are implementing similar export controls on Russia under their domestic laws. So there's a full list of those, and I think Michael's going to cover that later. But essentially, these countries have implemented their own very similar regulations. So if it meets those true criteria, then the de minimis classification under the new restriction would not apply. But if they don't, it would. So there are these new licensing requirements, and this is paired with a review policy of denial, and that is exactly what it sounds like. Applications in most cases will be denied. Some license applications will be eligible for a review on a case-by-case basis. Applicants will have to make a very strong case demonstrating that the export, re-export, or transfer will not benefit the Russian government or Russian defense. So these are going to be things that are like safety of flight, maritime safety, humanitarian needs. There are also certain kinds of companies that will get a little bit more preferential treatment. Those are going to be US wholly owned subsidiaries, foreign subsidiaries of US companies, certain joint ventures if the headquarters are in Group A countries. Essentially they're trying to create these carve-outs. So it's not, as Brian mentioned, as full as some of the other embargo actions. So in addition to the license review policy of denial, there are also a limited number of license exceptions that will apply. These are a list of the ones that still apply, and if you kind of read through them, you'll get an understanding of where the BIS is going with these. So we have things like temporary imports for items used by news media so that people still have access to information, GOV for government activities, TSU software and technology updates for civil end users that are subsidiaries or joint ventures of US or partner countries. The other important ones here are E and C, so encryption items, but it's not going to be available if you are sending your items for a Russian government end user or a Russian state-owned entity. Similarly, consumer communication devices, CCD, again, this is for consumer communication devices, but if these are being sent to government end users, it would not be approved. So these exceptions, BIS is operating under some specific foreign policy considerations and permitting exports that are intended to help the Russian people while limiting access of the Russian government and Russian military to US origin products. So there is also, under the new export controls, an expansion of the military end use and military end user scope. So under this new section, under 744.21 of the EAR, for exports to Russia, for military end use or military end users is going to apply to all items subject to the EAR. This section 744.21 includes restrictions on military end use and military end users in Russia, but also Burma, Cambodia, China, and Venezuela. So under this, you cannot export, re-export, or transfer any item subject to the EAR to Russia without a license if you have knowledge that the item is intended for military use or a military end user. So there is a specific knowledge definition that applies here. And, essentially it is knowledge of a circumstance, to know, to have reason to know, a reason to believe, an awareness of a high probability of a future occurrence. Awareness is inferred from the evidence, and you cannot willfully avoid facts to avoid knowledge. So there is some responsibility on the exporter in those situations. There are some specific exceptions to this for food and medicine that is designated EAR 99, or certain ECCNs that cover hardware and software that meet a specific mass market exception. So those are sort of the first kind of batch of license requirements on that have been imposed. And I think Michael is going to touch base on the foreign direct product rule now.
Yes, absolutely. Thank you both, Megan and Brian. So the foreign direct product rule, just as a little roadmap, I am going to, after the next couple slides, talk more about traditional, as you would say, economic Treasury Department sanctions. But for the first couple slides here, I'm going to continue to touch on export controls. As Brian mentioned, there are several ways that items can be subjected to the export administration regulations, and therefore, any export of those items must be in alignment with the export administration regulations. The foreign direct product rule is one of, I would say, one of the more complicated means of something becoming subjected to the export administration regulations. So as Brian touched on, under the foreign direct product rule, items that are produced outside of the United States, and I think this is what trips people up, items that are produced in a factory outside of the United States that have never, those items have then never been in the United States and never will be in the United States. Even if those items contain no US origin content, if they are, quote, the direct product of specific technology and software that is subject to the EAR, even if they're produced in a plant, let's say they're produced in a foreign plant where a component of that plant is a product of US origin technology or software, those items can still be subject to the foreign direct product rule. Now, prior to the Russian invasion of Ukraine, this rule did not apply to Russia. I would say the most commonly seen example of how this foreign direct product rule had been applied was in relation to the company Huawei in China, but now this has been expanded to Russia, and it really broadens the scope of items that are potentially subject to US export controls. So so under the new changes, there's two new foreign direct product rules. So there's a foreign direct product rule that applies to Russia generally, and then one which I'll talk about here on the next slide that applies to transactions when a Russian military end user is a party to the transaction. But under the Russia-wide foreign direct product rule, items can be subject to the EAR if they are the direct product of certain U.S. origin software or technology, or if they're produced, as I said, by certain plants or a major component of a certain plant is itself the direct product of U.S. origin technology or software. So this applies if you meet the language above, and it's known that such a foreign produced item, again, a foreign produced item, is destined to Russia or will be incorporated into or used in the production development of any part, component, equipment, etc., produced in or destined for Russia. Now, the next foreign direct product rule is in a way more broad, but in a way more specific as well. So this applies to military end users. Excuse me, let me take one quick thing. So this applies EAR controls when an item is a direct product of any software technology, not just specified software technology that is subject to the EAR. And once again, if such a product is produced by certain plants or a major component of the plant that itself is the product of such U.S. origin software technology. Now, this applies specifically if there is a party to a transaction that's what we would call a footnote 3 designated entity. A little background on that. The Bureau of Industry and Security applies, in essence, blocking sanctions. I shouldn't say blocking sanctions, applies restrictions to certain entities that it does not want U.S. Technology or goods going to. This is contained on the Bureau of Industry and Security entity list. When you look at the actual BIS entity list, all the entities, individuals, companies, etc., that are listed on the entity list will have certain information licensing notes, etc. Certain entities that have a footnote 3 designation that will link you to the foreign direct product rule regulations are subject to this rule. It's a bit of a nuanced, complex topic, and I'll talk about an important way here later on to try to identify if an entity is captured on this list, but it's something to keep in mind. And some quick considerations about these two foreign direct product rules. One, there is a savings clause. So items that are en route aboard a carrier to a port of export, re-export, or transfer on March 26th or by March 26th, 2022, can proceed to their destination without a license under this rule, even if they would otherwise be subject to the rule, because there's this is in essence grace period. So yeah, this rule becomes effective on March 27th. And as Megan alluded to, certain quote partner countries that the United States is deemed to be either adopting or having expressed intent to adopt similar measures to the United States are not subject to this rule. So if you have exports, re-exports, or transfers, which are called in-country transfers, from the following countries, they're not subject to these rules. So that includes, the countries are listed there. It's the majority of Europe, with a few key exceptions, Australia being one, New Zealand, Japan. Countries that the United States generally is more aligned with when it comes to export controls and sanctions. So shifting from export controls, from the export control world into the sanctions world, as just a quick primer, so the U.S. Office of Foreign Asset Control, which is a part of the United States Treasury Department, that's who administers what we would typically refer to as sanctions, U.S. economic sanctions. These sanctions are trade sanctions that are typically based on U.S. foreign policy objectives and generally national security goals. It's kind of the softer approach or the non-kinetic approach that the U.S. would take to trying to affect some type of foreign policy goal or objective. These sanctions can target anywhere from entire countries, somewhere like North Korea or Iran. From a U.S. sanctions perspective is the typical example of broad sweeping sanctions. But they can also be targeted and directed at individuals and certain entities. So individual terrorists or terrorist organizations, narcotics traffickers, etc., and anywhere in between. Following the Russian invasion, OFAC has imposed a variety of new sanctions. At this point, they are largely targeted at the Russian financial sector, I would say largely. Although they're also targeting certain Russian elites, basically Russian oligarchs, and some of their family members and some of their close associates. As Brian mentioned, there was some discussion and some, I would say, question as to what the scope of these sanctions would be. Would Russia at this point be treated essentially like Iran or North Korea? From a U.S. sanctions perspective, would it be cut off? At this point, it has not been. There are sweeping sanctions, but as Brian mentioned, these sanctions by no means cut off all potential trade with Russia. So jumping into some of the bigger moves, Sberbank is one of the Russian financial institutions that is being directly targeted by OFAC sanctions. Sberbank's, just as a little background, it's the largest financial institution in Russia. It's majority owned by the government of Russia, holds approximately a third of all banking assets in Russia, and according to the Treasury Department, is the main creditor of the Russian economy. So if you have any business engagements with Sberbank, I would recommend you look at Directive 2 to Executive Order 14024. This is where OFAC has directly targeted Sberbank, and the restrictions here apply to U.S. financial institutions. So under this restriction, within 30 days, all U.S. financial institutions are required to close any Sberbank, either correspondent or payable through accounts, and U.S. financial institutions must also therefore reject any future transactions involving Sberbank, or, and it goes beyond just Sberbank, any of its foreign financial institution subsidiaries. These prohibitions take effect on March 26, 2022 at 12:01 a.m. And the directive, in essence, retains the right for Treasury at a later date to subject additional Sberbank foreign financial institution subsidiaries to these same restrictions. So if at a later date, the directive is updated to include more financial institutions, these prohibitions will take place 30 days after such a determination is made. VTB Bank, another very large Russian financial institution, is actually Russia's second largest financial institution, holds approximately 20% of all banking assets in Russia, and like Sberbank, is majority owned by the government of Russia. VTB has been hit with more restrictive, we'll say controls, more restrictive sanctions than Sberbank has been hit with. VTB has been hit with what we would call full blocking sanctions. So what that means is OFAC has listed VTB basically as what we would call a specially designated national. OFAC maintains a list of specially designated nationals and blocked persons. VTB Bank is now on that list, and what that means is any assets held in U.S. financial institutions or held by U.S. persons is instantly frozen, in theory making it inaccessible to the Kremlin. 20 VTB Bank subsidiaries have also been designated as being owned or controlled either directly or indirectly by VTB. These subsidiary banks that have been identified are located in Russia, but also in 8 other countries, so the scope of this is fairly broad. VTB is a very large financial institution. And something quickly I'll note that's important to keep in mind, and I think this can trip people up at times. It's one thing to check the OFAC SDN list for blocked persons, but under OFAC rules, there's a rule called the 50% rule, is what it's typically referred to, as if you engage with any entity that is 50% or more directly or indirectly controlled by a blocked entity, so in this instance, VTB Bank, that entity itself is also blocked, which can make it a challenge because oftentimes these entities are not listed directly, right? They're not explicitly listed on the SDN list. So it requires a fair amount of due diligence and knowledge of your customer to understand if they might be owned 50% or more by VTB Bank or really any entity listed on the OFAC SDN list. The Treasury Department has stated this is one of the largest financial institutions Treasury has ever blocked. Later saying this sends an unmistakable signal that the United States is following through on its promise of delivering severe economic costs. Quickly going through this, a few additional financial institutions have been subject to OFAC blocking, similar to VTB. Russia's 7th largest financial institution, as well as its 9th largest financial institution, have been subject to OFAC blocking, as well as open joint stock company Sovcombank, who is not quite as big, but it is among the 50 largest financial institutions in Russia, and it seems to be it has been subject to OFAC blocking One, because of the size of its financial operations, but also because Treasury's identified it as, quote, the core financial institution for the Russian defense company Rostec. Together, these three financial institutions hold a combined roughly $80 billion US dollars worth of assets. The Treasury Department has said that these designations further restrict the Russian financial services sector and greatly diminish the ability of other critical Russian economic sectors from accessing global markets, attracting investment, and utilizing the US dollar. The United States is also imposing new sanctions limiting related to Russian-related debt and equity restrictions. This is specific to Directive 3 under EO 14024, so I'd recommend you take a look at that if you think that any of your activities might be related to this or implicated in this. These controls have been expanded, in the words of the Treasury Department, to cover additional key aspects of the Russian economy. And what this does is it targets, quote, transactions and dealings by U.S. persons. So specifically, if you are a U.S. person, and the definition of U.S. person is fairly broad, so I would take a look at that as well as persons located within the United States. Targets transactions and dealings with those individuals in new debt of longer than 14 days maturity, as well as any new equity of either Russian state-owned enterprises, entities that operate in the financial services sector of the Russian Federation economy, and any other entities that Treasury deems to be subject to these prohibitions. These restrictions take effect on 12:01 a.m. Eastern Daylight Time on March 26, 2022. At this point, there are six of Russia's largest financial institutions are implicated in this directive. And really the goal of Directive 3 here seems to be a general desire from the United States to limit Russia's ability to raise money through U.S. markets. The Treasury Department has actually said a key source of capital revenue. The U.S. markets represent a key source of capital and revenue generation. Imposing these restrictions limits the Kremlin's ability to raise money for its malign activities. Directive 4 under EO 14024 prohibits U.S. persons from engaging in any transaction, period, involving the Central Bank of the Russian Federation, the National Wealth Fund of the Russian Federation, or the Ministry of Finance of the Russian Federation. So the term there to kind of extrapolate upon is the term transaction. This prohibition includes, and the term transaction includes any transfer of assets or to such entities, or any foreign exchange transactions for on behalf of such entities. I mean, that's fairly straightforward. It's also important to account for the fact that these prohibitions relate to any transactions that evade or avoid, has a purpose of evading or avoiding, causes a violation of, or attempts to violate any of the prohibitions of the directive, and naturally, as well as any conspiracy formed to violate any of the directives of the prohibition. There's also been, and this has been something that's been more widely talked about in the media, sanctions of Russian, quote, elites. This is, again, Russian oligarchs, family members of Russian oligarchs, and various close associates of Russian oligarchs. And what the U.S. Treasury Department has done is basically list key Vladimir Putin allies and again, oligarchs. They've listed them on the OPEC SDN list, and they are subjecting them to blocking sanctions, just as, for example, VTB was subjected. Some of the key, you can see some of the key additions here: Sergei Ivanov, Andrei Patrushev, Ivan Sechin. These are all family members of close Putin allies, and they themselves are maybe not as directly closely related to Putin, but this is the point I'm trying to make here, is this is expanding beyond just necessarily Russian oligarchs and starting to encompass family members and associates of those oligarchs. Belarus has also been subject to various sanctions at this point, as I'm sure many of you are aware. Leading up to the Russian invasion of Ukraine, Russian troops have been stationed in Belarus, in southern Belarus, along the Ukrainian border. Reports are that Belarusian troops have moved into Ukraine as well. So the United States is now expanding sanctions on Belarus. The United States has actually maintained a Belarus sanctions regime for some time, but it's now been greatly expanded. The initial and primary move that the Treasury Department has taken in response to Belarus's activity is by, once again, subjecting certain entities and nationals of Belarus to OFAC blocking sanctions. So once again, that means they've been listed on the OFAC specially designated national or SDN list. And according to Treasury, this is done due to Belarus's support for and facilitation of the Russian invasion of Ukraine. So any entity or individual from Belarus, if they are listed on the SDN list, all of their property and their interest in property is basically frozen if it's in the United States or in control or possession of the United States person. Once again, keep in mind that the OFAC 50% rule comes into play here. So if you have somebody that's listed on the SDN list, that's straightforward. But it's very important to know, once again, know your customer, know your client to make sure that they themselves are not maybe an entity that is owned 50% or more by a listed individual. So as I keep bringing up, and I guess I'll wrap this up here before I hand it back over to Megan and Brian. I keep mentioning restricted party screening and the OFAC SDN list, and I referenced the BIS entity list, which is a list of individuals and entities that the United States government doesn't want certain transactions going to, or that restricts or subjects individuals to blocking. This is all great information, but how do you apply it? It really comes down to restricted party screening. And maybe this is something that, and hopefully this is something that a lot of you are familiar with. In my opinion, implementing a very thorough restricted party screening process and procedure is just absolutely critical if you're going to ensure that either you or your business are not at risk of violating any of these new blocking sanctions. Implementing restricted party screening, in essence, means you are looking at all the parties involved in a transaction and systematically and thoroughly checking them against various restricted party lists that the United States maintains. An example of that list would be the OFAC SDN list, which we mentioned, as well as the BIS entity list. The United States maintains really numerous lists that go beyond those two lists that need to be accounted for. If you or your business engage in a fairly low volume of transactions, it might be worthwhile to look at what's called the consolidated screening list. This is provided by the U.S. International Trade Administration. It's found on the trade.gov website, again, the consolidated screening list. And it's a web-based tool that you can basically input names of individuals and businesses and organizations and check them at one time against an updated consolidated list of all the restricted party lists. That's a great way, again, if you have low volumes of transactions, to start to ensure that you're not violating any of these blocking sanctions. If you're an entity that engages in a higher volume of transactions that would need to be checked, it might be overly cumbersome. It likely would be overly cumbersome to go and screen all the parties to all your transactions through the consolidated screening list. But with that in mind, there is third-party software that can integrate with enterprise resource planning systems that can help you to quickly screen large numbers of transactions. With that, I can hand it back over to Megan and Brett.
So I'll jump in here, Megan. This next slide has to do with the new regulations, new restrictions that were announced just yesterday, and we're not going to go into great detail. And but new restrictions on Belarus, full blocking of Russian defense industry and defense entities. Something new here are controls targeting oil refining. So we see some movement towards the oil industry, targeting entities supporting Russian and Russian military, and banning Russian aircraft from entering and using domestic U.S. airspace. So the sanctions do seem to be continuing to expand, and I mean, it may be before we're done, we'll see full sanctions or controls even on EAR 99 articles as well. Next slide. So just to give you an idea of the importance of compliance in this area, the BIS and OFAC both have tremendous penalty authority, up till $250,000 per violation, and we're talking about violation as an individual shipment. or release of technology. So it's very, very important that companies, to the extent they continue to do business in exporting to Russia, that they do things correctly and are very, very conservative in terms of applying and understanding the regulations. There's also the possibility of denial of export privileges, which is basically the death penalty of the export control regime, and additional administrative and criminal sanctions as well. We have a couple additional slides on those penalties, but I think probably the point's been made. So I know there are many questions, or there may be many questions. We're running kind of close to the deadline here, but if there's anything that we can handle in the next few minutes, please let us know. And if not, we are available individually as well. I think that many of you are already familiar with our firm, and you have our email addresses and telephone numbers as well. And if we can be of any assistance in navigating through this maze, we'd be glad to be of any help we can.
Brian, Megan, Michael, thank you very much indeed. That was absolutely fascinating. We do have a few minutes to have questions. If we can go back into the main room, we can, if you have questions, either pop up a virtual hand, or make yourself known. I can't see everybody, that's my problem, so I'm going to have to rely on you. If we make yourself known, you'd like to ask any questions. While you're thinking about it, Brian, you put out a fascinating article which covered some of the issues earlier on. We shared that with members. Presumably, as this is a fast-moving world, will you be adding to that and putting out other updates on latest developments?
I expect we will, and we have a newsletter, the Trade Express, that article was part of, and that comes out regularly. So we'll push it out to you directly, Quentin, and feel free to share that as well. Information is also available on our website, and that's updated fairly regularly as well.
Okay. And can people sign up to your newsletter if that's what they would like to do?
Yes, absolutely.
Lovely.
Drop me an email, and we'll take care of it. My email is bwalsh@barnesrichardson.com. Perfect.
We'll share that. We'll share that after the session. Okay. So right. So there's a question from Christian. Christian, we chatted the other day from Denmark. You raised a question. Do you want to just introduce yourself and then ask the question yourself? Can't hear you.
Sorry, I think maybe you can hear me now. Hello.
Perfect. Thank you.
Yes, I'm Christian, also from Leuven in Denmark, a new partner in the firm. I come from Gorsen Philipsbiel, where I've been for 26 years doing litigation and IP, mostly media and entertainment work. Yeah, I just raised the question, and I wondered actually, I think I recall that during the Trump administration there was some restrictions to trade with China, and I'm not familiar with those measures have been more or less abolished or been lenient, but I just wondered whether, at least in the current situation, and with the possibility of also products having US parts and Chinese parts, if there could be any special issues with expectations to it, restrictions on China and trade with China.
So China is subject to the entire range of controls that we talk about under the BIS. Now, the level of control is less than it currently is from Russia because we have elevated levels of control for Russia. And under OFAC as well, there are many individuals and entities that are sanctioned within China. So they are subject to similar sorts of controls, but and are at a lesser level of control than Russia currently, where licenses required for everything but EAR 99 articles. But they are subject to an elevated level of control compared to, say, our European trading partners, for instance. Now, there has been some discussion of the possibility of secondary sanctions, which would extend the sanction regime that we're seeing applied to Russia to various suppliers or customers, particularly in the defense industry, which would deprive Russia of the benefit of foreign trade for sales of defense articles as well. So that is a possibility, but that hasn't happened yet.
And if I can make an addition here. So Christian, and something I think you were alluding to as well, under the Biden administration, we actually have not really seen a lessening of restrictions that had been imposed by the Trump administration. Now, the big question is, right, there's a presumption that Russia and these Russians somewhat inoculated from Western sanctions because China could potentially serve as a market to replace European and US exports. What will ultimately happen with that, I don't think anybody knows. I know China yesterday put out a statement that they will not be imposing any sanctions, as far as I know at this point, on Russia. And the United States, as of maybe about 2 weeks ago, had said any Chinese entities who work to help Russia circumvent US sanctions and export controls may themselves be subject to US sanctions and export controls. But at this point, there's nothing definitive about that. There's nothing in writing that spells out exactly what could happen, but that's something that the Biden administration has certainly at least alluded to or warned about.
Thank you, Christian. Thank you, Michael, Brian. Any other questions for the team at this time? Just keep my eye out. Okay, thank you. As Brian said, I'm sure if you've got questions that you would like to ask, I'm sure Brian and the team would be very happy to answer those after this session. The recording will be made available to you all and to the membership, so you can review that. And then, as Brian said, if there are updates, or as and when there are updates, we will make sure that you have them as well. But for now, thank you very much indeed to everybody for attending. But in particular, thank you very much indeed to Brian, to Megan, and to Michael for what was an excellent and fascinating presentation. I wish you all the very best, and look forward to seeing you again another time. Take care.